an attorney that practices in employment law. I've been practicing for about 25 years now. And I know you're thinking, she's so young, right? That's what you're thinking, how could I work for that long? I know, I can see it on your face. But I really am very young looking. That's really the issue. I'm quite old. I'm going to talk to you about unlawful harassment. I'm not going to tell you how to act. I'm not going to tell you what to say and what not to say, because that's really your business and not mine. But I am going to talk to you about what the consequences are, either if you feel like you've been treated poorly by a coworker, or what happens if you yourselves might say something to somebody that they find unwelcome. So that's kind of the way it works. I am a 2 Volvo family, and so I thought when I saw the silver S60 come in, that was my car being serviced. I asked Pat if I could get it serviced at the same time. He said no. It's not true. I just had it serviced. So anyways, I'm a big fan of Volvo, so I'm glad to be here. What I'm going to just start out by talking about is what are the protected classes that, first of all, great picture, yeah? Another, yeah. And I'll just tell you that I'm so vain as I get older that it's 2 different, it's hair from one photo and face from another. They photoshopped it because it was unacceptable. So my hair always sticks up. Let's see, is this, there we go. All right, so everybody heard sexual harassment, cell environment harassment, you guys all heard that expression before? Yeah, okay. So you don't have, though, unlawful harassment, you don't have sexual harassment, unless you have a protected class. So I started by telling you what the protected classes are under state and federal law, just so you guys kind of know for the future what they are. So under state and federal law, Minnesota, you're protected from discrimination. Discrimination includes hiring all the way up to termination and everything in between. Based on race, color, religion, creed, sex. Sexual harassment is a form of sex discrimination. Sex discrimination includes pregnancy. That's a very hot topic these days. National origin, what country you're from, whether you're Swedish or Norwegian or Finnish or Italian. Disability, whether somebody has a medical condition that's considered to be a disability. Age, over the age of 40 under federal law, over the age of 18 under Minnesota Human Rights Act. Genetic information, that's a new one, which was added a few years ago, so you can't refuse to hire somebody based on their family medical history. Like, for example, if I disclose that I had the gene for breast cancer, and my family and my employer said, I don't want to deal with you, or my prospective employer, I want to hire you because I'm going to have to pay big insurance premiums. That's genetic information. So that's unlawful discrimination, potentially. Marital status, whether you're married or unmarried, or the identity of your spouse, that's a protected class. Status with regard to public assistance, nobody really knows what that is. Sexual orientation, in Minnesota you're protected from discrimination based on your sexual orientation, whether you're gay or you're straight, if you're transsexual, if you're a cross-dresser, and everything in between. So broad category here, and then this is the one that really nobody knows. Membership on a local civil rights commission. Who knows what that is? But basically, so sexual harassment, unlawful harassment, is a form of discrimination. But it takes place when you're at work, unlike failure to hire or termination. Harassment is a form of working environment behavior. But if you have substantiated harassment, you got a problem as an employer or as an employee. The one other thing I didn't have on there was retaliation. And retaliation, it protects employees who make a complaint at work. And the problem, from my point of view as a lawyer who defends lawsuits for employers, is that you can take a really bad complaint, like, let me just pick on you. What's your name? Jim. I didn't like the way you looked at me, Jim. I'm going to complain to Pat. And everybody thinks, what's wrong with you? That's the stupidest thing I've ever heard. But then Jim decides that he's not going to talk to me. He's not going to give me any work. He's going to ignore me. He's going to tell everybody I work with and I'm a jerk. That's potentially retaliation. And retaliation can happen independent of the validity of the underlying complaint, right? So you can create a retaliation claim out of a out of a stupid complaint. I'll give you some examples in a little while about a case that we had in the office. So retaliation is a problem, and it's the #1 claim that employees file with the EEOC or the State Department of Human Rights. Retaliation claims. So it's as much a problem as actual discrimination. Anybody have any questions? That's the other thing I forgot to tell you. If you just sit there and stare at me, which I have a feeling you're going to do, maybe not Jim. Yeah, you smile. Thank you. That's helpful. It's better than like staring daggers at me. Do ask questions. I bet you won't, but I'm just saying do. I'm glad I dressed warmly too because, you know, we're in a garage. All right, so 2 kinds of sexual harassment. I'm going to start out just by talking about sexual harassment. 2 kinds of sexual harassment: quid pro quo and hostile environment. And quid pro quo is favorable or unfavorable treatment at work based on sex. So I'll give you a job, I'll give you a raise, I'll give you a favorable performance evaluation if you go on a date with me or if you have sex. Hollywood casting couch, right? I'll give you a role in my movie if you sleep with me. We don't see those kind of claims very often, I'm happy to say. But, you know, it's the kind of old fat, the boss chasing the secretary around the office type stuff. So that's quid pro quo. We don't see that. The only time we do see it is when you have 2 people at work who are dating, and sometimes you can have perfectly happy dating relationship, but when they break up, things go south. And that's where we tend to see them, but not very often. By far the most common claim we hear is hostile work environment. I'm assuming you've all heard this over the years, whether you read the paper or watch Fox News or CNN or whatever, you hear about hostile environment, sexual harassment. And so what I'm going to do is, or it's hostile environment harassment, what I'm going to do is just kind of break it down a little bit to give you some practical tips about what it really is, so you know basically not to do it. That's really all I'm asking you to do. At work, do what you want to do outside the office. Try not to do this stuff at work. So hostile environment harassment is the creation of an intimidating, hostile, or offensive working environment that has the purpose or effect of unreasonably interfering with someone's employment. So if someone's working in an environment, whether it's intentional or not, that's so charged with inappropriate discrimination, comments, jokes, etc., and interferes with their ability to do their job, that's going to be potentially unlawful harassment. Does that make sense? What is it really? Well, it can be a bunch of different things, and I'm going to give you some examples in just a minute of inappropriate behaviors that take place at work that create, in total, a hostile working environment. My practical definition, though, repeated, one-time dirty jokes are going to be unlawful harassment, or one-time stupid thing that you say at work. It's got to be repeated, it's got to be unwelcome, and it's sexual attention. That's what we're trying to keep outside of work. Repeated unwelcome sexual attention that a reasonable person would believe has created a hostile or intimidating work environment can be sexual harassment. That's the practical definition. Anybody have any questions? Now we're getting serious, right? You're not smiling at me anymore. No, you're smiling without showing. You're smiling inside, right? Yeah. All right. One thing I want to make sure that I said right from the beginning is that I made a lot of the examples you hear about sexual harassment are male or female, and I don't want you to think for 1 minute that it's limited to that. So, of course, I've had male to female sexual harassment claims, but I've also had female to female sexual harassment claims. So I had a case years ago where a supervisor asked all of her subordinates to go to the strip club with her. Kind of dumb, right? Can we all agree that was dumb? And if we can't, then I'll talk to you afterwards. No, she took her employees to a strip club, and then she bought one of her employees a lap dance. Bad. Female to female or female to male sexual harassment, that exists. and then male-on-male sexual harassment. And my law firm had one of the first cases in the country on male-to-male sexual harassment. And it was at, you guys can all laugh, at a meatpacking plant. Laugh. But here's what happened, and it's such a good example of what sexual harassment is. It wasn't a bunch of guys hitting on other guys. It wasn't that at all. It was hazing that got so bad that it had a sexual component to it. I mean, it involved sexual gestures, sexual jokes, sexual comments, that these new employees would quit their job rather than deal with the guys that had been around forever. So harassment, unlawful harassment, isn't necessarily about hitting on somebody. It's about bad behavior at work involving sex that creates a hostile environment. Does that make sense? All right, so let me just give you some examples here. All right, really small type, sorry. Sexual flirtations, propositions, invitations to social events. Jim, you want to go out for a beer with me on Friday night? Do you think that's inappropriate?
Invite?
Yeah, of course, I'm Right, inappropriate or not inappropriate? What do you think?
Yeah.
It's not inappropriate? No, it's fine. I mean, it's just an innocent social invitation. But Jim says, no, thank you, I'm happily married, I really don't want to go out for a beer with you. And I keep coming back and saying over and over and over again, come on, Jim, let's go out for a beer, it'll be really fun. That is not sexual harassment, but isn't the kind of behavior that can create a problem? You bet. Why? Because it's repeated and it's unwelcome. He's already told me he's not interested, right? Lewd jokes. I mean, obviously, I can't tell you never to tell a dirty joke because I just don't think the world works that way. But I can tell you that if it's repeated and if somebody indicates to you that they're offended and you keep telling the joke, again, not that any of you would do this, that's where the problems are. Sexual anecdotes, stories. What'd you do this weekend? What you going to do next weekend? You know, who's the new date on Match.com or whatever. Those are all the kind of things that work that can create problems. Sexual gestures. Making comments about someone's appearance, clothing, or body parts. Jim, I really like your jeans. How's that? Problematic? You look really hot. Those jeans make your butt look great. Problem? What's the difference between you look nice versus I like your butt in those jeans? Anybody? You're not going to volunteer. I know the answer. So you tell me. What's the difference? Sex, right? I mean, clearly if I'm saying your butt looks great in those jeans, I'm referencing it's sexual attention. That's why I use that example. And if he's uncomfortable with it, it's unwelcome sexual attention. Or, I mean, the other one I always use, leering, whistling, staring, or touching or grooming. So I stand really close to Jim, ask him to go out for a beer with me and say, your butt looks hot in those jeans. I mean, that's a whole bunch of little things that you put together that's probably going to make him, going to make him uncomfortable because it's about sex. That's what we're trying to keep outside of the workplace. Asking sexual questions, talking about someone's sexual history, hazing, making sounds, rating somebody's sexuality. She's a 10, he's a 10. Name calling, making sexual ridicule. And then the one that I think has kind of made my job as a lawyer so much more interesting is pictures, calendars, cartoons, or other materials. When I first started practicing, any sexual harassment claim that had a calendar involved the Tool Time Girl or that, something a long time ago, just pictures kind of suggest Playgirl, Playboy. Now, what can you get on the internet? Pretty much anything you want to. And you all, how many of you have iPhones, smartphones? Everybody in the room, right? So you can look at whatever you want to on your phones. And what happens is people bring it to work. And so it's created a whole new world for me as a lawyer. So I had a case probably 15 years ago when the internet was getting big, and I guess email's been around longer than that, where some lady sent a picture of herself naked to one of her coworkers using the office email. Right? How embarrassing! I mean, how truly embarrassing. And then when she got fired, what's the first thing we show the unemployment judge? Picture of her naked. I mean, again, how embarrassing, how stupid. But people do stuff. I mean, I'm sure you've read about people. There's a guy who got fired from one of the trucking companies in Egan when he was looking at porn on his phone during lunch hour. So what I always say is, look, if you are free to do what you want to do outside of work, but just don't do it at work, right? That's where the problems start, is when you're doing any of that kind of stuff at work. So let me just use a less obvious example. Sports Illustrated Swimsuit Edition. How many of you have seen that? Everybody? And what is the Sports Illustrated Swimsuit Edition about? Swimsuits? Sports, right? Swimming, I've heard. You know, it's about all sorts of things, right? But let me ask, so how many of you think it might have something to do with sex? Right, thank you, I knew the woman would. Right. Now, it's not pornography, it's not illegal, it's not, you know, you get it in the dentist's office. My 17-year-old kid gets it because he subscribes to Sports Illustrated. So I'm not saying you can't look at it, but to me, it's an example of the kind of magazine that's probably best kept outside of work. Why? Because if you have it sitting on the break room table, right, it gives everybody an opportunity to talk about something that's probably best not talked about. That's all. So again, am I saying don't look at it, don't read it? No, I'm just saying that's an example of the kind of document that you probably keep outside the workplace. So, I mean, I kind of similar. Once somebody asked me a question about Baywatch. So in the break room, they always had Baywatch on. And they said, is that unlawful? It's not unlawful to watch Baywatch. I mean, what a great, fabulous TV show it is. But is Baywatch about lifeguards? No? Saving lives, right. Just like the swimsuit edition is about swimsuits, yeah. But what it did was it caused people to, oh, look at her, look at Pam Anderson, blah, 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 blah. So we just said take it off, you know, don't have it on. All right, so I just gave you examples of behavior that could create a problem, create sexual harassment. Whenever you have at work repeated unwelcome attention about someone's protected class, race, color, creed, sex, religion, national origin, age, about people's protected class, whether it's intentionally about their protected class or not, that could create a claim of unlawful harassment. So, for example, am I making you crazy walking around like this?
No, it's great.
You know, negative stereotypes associated with someone's protected class, mimicking somebody's accent, nickname, inappropriate racial nicknames, making negative comments about an employee's religious beliefs. I had a case years ago where a guy was a salesperson, and he traveled with his boss, who was a devout Lutheran, like an evangelical Lutheran. The employee, the salesperson, was a devout Catholic, and they would talk about religion on these long road trips. Which, yeah, okay, maybe not the best thing. But then when the employee got fired, he said, you didn't fire me because I'm a practiced salesman. You fired me because you don't like my religion. And the only reason he could say that is because the boss would have these long conversations and say things like, why do you people believe the Pope is infallible? I mean, that's not such a great thing to say. I mean, first of all, you should never say, why do you people? That's an example of what you should say at work. But that created a claim for the employer. Talking about someone's skin color or other ethnic traits. Racist drawings, posters, bumper stickers, all that kind of stuff. Offensive gestures, making fun of someone's mental or physical status. Sharing inappropriate emails, images, letters, you know, all that kind of stuff. Making derogatory age-related comments. Or wearing clothing, or having a visible tattoo. There's a pretty famous case about a guy, a skinhead in Milwaukee, who had a swastika tattoo and just got the crap beaten out of him by his coworkers. And I don't know, you know, if that's a good thing or a bad thing, but you know, clearly that was a out-and-out statement of his racism. But I think that's how his coworkers interpreted it. Let's put it that way. So these are all the kinds of behavior that could create a claim of unlawful harassment and then the examples of sexual harassment. Does that make sense, everybody? Yeah? All right. So, couple of key concepts for you all to be aware of when it comes to sexual harassment, or unlawful harassment. The problem with the what's inappropriate is that it's a subjective standard. So everybody in this room gets to set their own standard. What I think is funny, what you think is funny, what Jim thinks is funny, the law's not going to say you're dumb for thinking that's offensive. Now you might, that person might be, but they're not going to say you don't get to have your own standards. So you can, you're dealing, how many people in the entire Borton Volvo workforce? 100, 150, 80? How many? Yeah. All right. So that means you got 80 different standards. So that's all. I mean, that's a lot of different potential people. You know, you've got prudes, and you've got people who aren't, and you've got people all over the place. So you can. Everybody gets to set their own standards. So the other piece too is that the intent of the harasser is irrelevant. So I gave you the definition earlier of unlawful harassment, and the behavior need only have the purpose, so you can intend to do it, or the effect. So that means that somebody can be subjected to unlawful harassment where the person who's engaging in the behavior never knew they were offending the person. And I think that's a problem too. I mean, have you all ever had a situation where you've unintentionally offended somebody in your life, right? Or, you know, you're a coworker, you make a little joke, and I mean, believe me, I've learned over the years of working in a law firm to never, ever venture a political opinion, ever really with clients or anybody. Just because you never know, right? So that, you know, that it's not the intent of the person who's engaging in the behavior, it's the effect on the person who listens to it that creates the potential claim. So two subjective standards. The other one, and this is the one that makes everybody crazy, is that the behavior, well, these two together, the behavior doesn't have to be directed. So I'm walking down the hallway with Jim. Jim, I tell Jim kind of a risque joke, right? I think it's funny, you think it's funny because we go way back, no problem. What's your name? John overhears what I say, and John's like, that's awful. I can't believe you said that. And he's going to go report me to Pat. And what's our natural response? Well, bug out, you know? I mean, it's not your business. I was talking to Jim. But the law is going to protect people, whether they're subjected to the conversation or not. Why? Because the law kind of had its, I worked in a lot of construction companies. So if you're a apprentice electrician, just for example, or plumber or whatever, you're sitting at a table with a bunch of master electricians. They're telling dirty jokes, and you want a job, right? You're not going to go complain about them, right? You're not going to say to them, knock it off, because the law kind of presupposes that people have difference in power, right? So it doesn't have to be directed at the person, nor do you have to say, knock it off. I have the right, I have to complain, but I don't have to complain directly to the people that are engaging in the behavior. Because they're going to protect people who can't stand up for themselves. And I mean, I think there's a lot of, I hope you have the kind of working environment where somebody can say, hey, knock it off, you're being a jerk. I don't know whether you do or you don't, but I think it's one of those things that is kind of easier said than done, right? So, those are kind of two parts of the same coin. The other thing is, just because you're sitting at a table and you've got a bunch of people telling jokes and somebody doesn't say, I'm offended, that may be voluntary, that doesn't mean it's welcome, right? Welcome means I'm participating, I'm telling the jokes too. If I'm just sitting there saying nothing, don't assume that it's okay. Does that make sense? Okay. Is there a difference between inappropriate behavior and unlawful behavior? You bet. So you can have a bad joke be inappropriate, and it might violate your policy, which I'm going to walk over here and get in just a second. But it's not unlawful because it's a one-time joke. We're not in the business of suing over one-time jokes. But the policy against sexual harassment and other legal harassment prohibits both inappropriate behavior and unlawful behavior. So there is a difference under the eyes of the law as well as in terms of your policy. Is it unlawful? Have you ever, anybody here ever worked with somebody that's rude? Coworker? Boss? You're not going to admit it, right? Because you're doing it in front of you. Oh, yeah, no. I know I sometimes do. Disrespectful. Anybody work around disrespectful people? Disruptive people, or just plain mean people. I remember I'm a lawyer and I work in a law firm, so I can assure you that I've worked around when lawyers are rude, disrespectful, disruptive, and mean. That's what we get paid too. Sorry. So, is that unlawful behavior? And let me just give you an example here. Anybody here a Green Bay Packer fan? Anybody? No? All right. Anybody? Well, I'll change the sport. Anybody a big Kansas City Royal fan? No? Come on,
Come
guys.
on. Wake up back there.
All right. Well, you're like, I'm just going to stop talking. If you guys are not going to, you're probably thinking that's great.
I love the Royals.
You love the Royals. Anybody love the Giants? You're just pretending for me. Thank you. Okay. Doesn't matter. The idea being that you have two people on. I actually want the Royals to win, even though I recognize I'm a big baseball fan. Even though I recognize why the Giants might be a better team, I want the Royals to win. So let's just say you are Tyler, and you are
Chris.
All right, so, and you're pretending to like the Giants for me? Yeah? Okay. So, thank you, Tyler. So you decorate Chris's locker, and you send around emails, or you put stuff on her car that says, you're a loser for liking the Royals. I just will note that you are wearing a royal blue cap. Yeah, okay, very good. And you're like, this is way overboard, Tyler. You're just, back off. Is Tyler's behavior unlawful harassment? No. What? Not if you stop. Okay. Anybody else? You're saying no. I'll ask you in a minute why. Anybody? Why do you think it's not?
It's obnoxious, but it's not illegal.
Obnoxious but not illegal. Right. Why? Because being a Royals fan or being a Giants fan isn't a protected class. You only have unlawful harassment if it's based on race, color, creed, sex, religion, national origin, age, disability, marital status, blah, 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 blah. You might have bad behavior. You might have obnoxious behavior. You might have generally harassing behavior, but it's not, and you can do something about it, obviously, but it's not illegal. Why? Because it's not based on a protected class. And if you look at your policy prohibits unlawful harassment. I'm sure it protects a lot of other, or prohibits a lot of other things, but the unlawful harassment policy applies to harassment based on a protected class. Does that make sense? All right. Well, you've taken the joy out of my example. I just want you to know. I don't think I've ever done this where there hasn't been somebody who is a Viking and then a Packer fan. I've never, in my 25 years, ever had this happen.
Yeah, that's odd.
But that's odd.
Mm-hmm. I don't trust these guys.
You always get somebody that's a fanatic, particularly the Green Bay Packer. I mean, they're like, they're extreme in their religious beliefs about their. Yeah. All right, so just brief. So you've got a policy against sexual and other harassment, and it really just talks about exactly what I just talked about in terms of the prohibited behavior. If you believe that you've been subjected to inappropriate behavior, or somebody else has, you are required to tell somebody in management about it so that the management can do something about it. That's the key part of the policy. If the company is aware of inappropriate behavior, the obligation is to look into it and do something about it. At the end of the day, that's kind of the most important piece that you all should know about. And then, if the employer, gets a report, then they have to do an investigation. It doesn't have to be a big investigation. It can be a small one. It can be asking whether something happened. I've had them all over the place, but you have an obligation to look into it. And then, if you find the behavior occurred, to make sure that it doesn't happen in the future. Prompt investigation, thorough, fair, effective monitoring. That's the piece to make sure it doesn't happen again. So here's a couple of things that are really important to cover in terms of that's based on an excuse. So what's an excuse to a claim of unlawful harassment? I was only joking. Why is that not an excuse? Anybody have a guess?
Whether it was a joke or not, you still said it.
Exactly. Intent is irrelevant, right? Doesn't matter whether I intended to. One thing I do want to say, because I forgot to say this earlier, is the case we had years ago was a woman who brought a lawsuit claiming that the Montgomery Ward catalog was inappropriate behavior, right? So anybody here old enough to remember the Montgomery Ward's catalog that had men in their underwear? JCPenney's, go figure, I don't really understand that, but it did. So somebody left it on the workroom in the lunchroom. She saw it, she was offended by it, she made a report. So why isn't that sexual harassment? If what she gets to set her own standards, she was offended by it, okay, obviously there's some serious, deep issues with you, lady. That's offensive to you, but fine. The reason it's not sexual harassment is because even though she gets to set the standard and nobody intended to offend her, reasonable people wouldn't agree that that behavior is so severe that it alters your working environment. So you've got a subjective standard in terms of what's offensive, and you've got an objective standard in terms of whether or not it's truly illegal. So who do you think, though, the reasonable people are that would agree or disagree that the behavior created a hostile environment? Anybody have a guess? No. No. The good guess, thank you. Who? The jury, right? We don't want to have the jury decide whether or not reasonable. I mean, the jury is the reasonable person. So our goal is to not have a jury decide, because I think you kind of dodged. I mean, there was no problem with that one, but there are other cases where I've had the jury decide and it went against what I thought was reasonable. So, no company wants to have their business out in front of a jury. It's okay. He's got to do his job, right? So, we're friends, or I thought we were friends. The thing about unwelcome behavior that focuses on a protected class is that you get to set your own, right? You get to set your own standards, and they might change. So, has anybody been in a situation where you've said something to somebody, your friends, everything's fine, but maybe you make a crack about, I'll just use something, not their mother, their wife, sometimes people unintentionally cross the line. So I get to change my standard even if I participated in the behavior in the past. Does that make it so it's a better defense to a claim? Yeah, if I participated in something, one day I say that's enough, it's going to affect how you evaluate the claim, but I do get to change my standards. I'll just use a different example. So I'm participating, I go out drinking, I have a great time, I tell all these, jokes, and I'm well in it with everybody, and then one day I find religion. And I say, we're done. I just reset my standards. Now, does everything else that happened in the past come into play? I would say no, but I've set my standards, and I get to change my standards going forward. we're both of the same religion, gender, race, age, etc. That's not really a defense to a claim of unlawful harassment. Courts recognize you can have two people in the same protected class create unintentionally or intentionally claims. My favorite, I'm an equal opportunity offender. Anybody that's hey, I'm not picking on you because of your protected class. I'm a jerk to everybody. Again, that's a really, I'm sure your employer wants that to be the defense, but courts kind of see through that sometimes. So a pretty famous case from Atlantic City where I think it was at one of the Trump casinos, the pit boss got sued for sexual harassment. And he said, I'm an equal opportunity offender. I'm a jerk to everybody. And the evidence showed that to be the case, except for what the court focused on, the names that the guy called women versus the names that he called the men. And I'll leave it to your imagination to think about what that might be. And the court said, based on the names, how you talked to the women, it was clearly sexual. And therefore, it's unlawful, and Trump, you're liable, which I don't actually have a problem with Donald Trump being liable for anything. That's just my own opinion. A couple things here. It's not our employee who is the harasser. You guys are in a service business. In fact, most of my clients are. And so what do you do if you know, and I'll use a real life example. My office, so you've got the UPS guy coming in. You were at the front desk when I came in. Are you the normal person at the front desk? Normal person at the front desk. And somebody's, well, okay, the usual, the customary and regular person at the front desk. Somebody's hitting on you and saying all sorts of inappropriate jokes, and you can't throw up your hands as an employer, and nor should you not report it, because if you report the behavior of a third party to your employer has an obligation to do something about it. Similarly, if it's our employee who's saying something inappropriate to the UPS man, and that's where my real office example came. I was walking through the front entryway of our office, and there was about 6 secretaries standing around the front desk. I'm like, hey, what's going on? They said, oh, we're all waiting for the UPS guy to come. He's really hot. And I thought, oh my Lord. No, this is the cobbler's children have no shoes, right? I mean, I said, you guys, he obviously is going to know that you're all sitting there checking him out, and do you understand that's inappropriate? But that's our employee engaging in inappropriate behavior. However it occurs, your obligations as an employer, and yours if you want to report it or refrain from the behavior, it doesn't change. It's the same all along. The other one is the conduct occurred while I was doing it on premise. Employees, you guys are free to do whatever you want outside of work. Employers are in the business of regulating your behavior. However, the minute it comes back to the workplace, it becomes the employer's business. And you're thinking this never happens, right? At least once a year, I get a case where 2 employees have restraining orders against each other all the time. Or the police are involved in, slashing of tires, and I mean, so people have a consensual sexual relationship out of work, and then they, something happens and they fight at work. It happens all the time. So whatever you want to do outside of work, your business. However, if it creeps back into the workplace, it becomes the employer's business. So, am I almost done? I am almost done. Oh, I am done. I mean, isn't that great? All right, so here's the thing. Don't engage in the behavior. You're not going to, I have confidence in all of you, particularly you. Senior leader, okay. Don't engage in the behavior, and if you're comfortable, if you see the behavior occurring, if you're comfortable, just tell somebody to knock it off. I mean, as little as, hey, you don't have to make a big deal about it. Hey, I heard you make that joke, and just the expression on his face or her face made him uncomfortable. Just don't do it. I mean, that's really an important part of this whole unlawful harassment thing, is to kind of monitor yourself. If you believe that you've been subjected to inappropriate behavior, report it. Report it to whoever you're comfortable with. It's not going to be confidential, but it will be discreet. And if it's your boss that you're worried about, tell your boss's boss. Doesn't matter who in the chain of command, just make sure that people know about it so that the company can do something about it, because that's the most important thing in terms of stopping the behavior. And then don't trivialize other people's behavior. I mean, that's the thing too that I see. Oh, and I hate to use my own law firm as an example, but I will again. But there was this guy that used to work there many, many years ago, and everybody knew he was a dirty old man, right? I mean, he just said the most inappropriate things. And everybody would go, oh, don't worry about him, that's just the way he is. Well, by doing that, aren't we just letting it continue to happen? Somebody needed to say, hey, knock it off. You're gross. That's really what I should have said to him, and of course I didn't. And so, you know, don't trivialize bad behavior. Report it. Deal with it however police resolves, that's appropriate. But that's it. That is it. So, I started late, I ended early, which usually gives me a good evaluations. And the other thing too, and I forgot to say at the beginning, is my goal in doing these sessions is to have you all walk out of here and go, that was not so bad, right? That's a pretty low standard for me to set. You know, it could have been worse. It could have been a really boring lawyer. I'm not a boring lawyer. I mean, it's, you know, it wasn't that bad, right? Come on. It's not that bad. All right, so now go away. And don't engage in bad behavior, all right? Go to your lunch, go fix cars, whatever it is that you do. Thank you very much.